Sexual abuse statute of limitations. Favorable report is amended. Adopted.
The special order counter, the motion is made by our good friend from Charles County.
Thank you, Mr. Speaker. All my questions have been answered.
Okay.
Mr. Speaker.
Gentlelady from Montgomery.
Thank you. I have an amendment at the desk. I believe 563, sorry, I can't read, 563-822/1.
Amendment number 1.
Thank you, Mr. Speaker. This amendment...
Committee doesn't have a copy of the amendment.
Oh, I'm so sorry.
The chair would like to thank the majority leader for the copy of the amendment.
I do apologize. We did at least communicate last night about what I intended to do. This amendment very simply strikes, the only thing this amendment does is strikes the retroactivity that is at the end of this bill. We have a disagreement between the committee chair and I, and perhaps others, as to whether or not retroactivity is constitutional. The reason that I object to the retroactivity is because in 2017 we passed a bill, and part of that bill included something called a statute of repose. And it's in our existing law. Statute of repose indicates that you cannot revive past claims. And that is the reason that I object to the retroactivity piece. I have a very long, several letters from the Venable law firm that talk about the fact that the statute of repose precludes us from passing that piece of the committee amendment. I have asked for an AG letter, but I haven't received it. It is correct, as I imagine the committee chair will say shortly, that before the committee voted on this, they had received an AG letter. I've read that letter. That letter does not, in any form, address the statute of repose, which is the reason I asked yesterday for an AG letter, so that we would have the information from our AG. Obviously, I have my own personal opinion, as well as the opinion written in several different letters from lawyers, that the statute of repose will control. If we pass it, in my very humble opinion, it makes it unconstitutional. I would therefore respectfully ask to accept this amendment. And again, the only thing amendment does is strike the retroactivity, which we addressed in 2017 in House Bill 642 of that year, where we included a statute of repose. I move the amendment.
The chair of the committee.
I'd ask the chamber to reject the amendment from the majority leader. We did, in fact, get a letter from the Attorney General asking specifically with regard to the look-back provision that is in the bill. We asked for it. The committee was given the letter. They were given the letter to read, then come back the next day and then take up the bill. On an issue like this, there was nothing in that letter about the statute of repose. And quite frankly, I believe that an issue regarding a statute of repose is going to be something that's going to have to be taken up by the courts anyway. It's going to have to be taken up in the context that, frankly, this is an issue that is growing in magnitude every single day. It is growing in magnitude across the country as we start to find more and more people who have been moved around the country to avoid issues in one place, or they've been moved one place because there has been an accusation, so they end up in another place. We're finding out a whole lot more, and there is becoming, I think it's clear to myself, and I will say to the 17 members of the committee who supported this bill, a need for people to be able to bring claims against those people who were abused. That's what this bill is about. This bill would state the clear intention of this legislature that those people should get relief. And that's why I'm opposed to this amendment. Thank you, Mr. Speaker.
On the amendment, the gentleman from Charles.
Thanks, Mr. Speaker. Would the maker of the amendment please rise for a question?
Certainly.
Who was, what was the bill that, the 2017 bill, whose bill was that?
It was your bill.
It was. Could you explain what a statute of repose is?
Yes. A statute of repose is a shelters legislatively designated groups from an action after a certain period of time.
And where in the bill was that?
It was in Section 3,
The uncodified language?
the uncodified language, but that still becomes law.
So, I just want to make sure. So it was in the uncodified language, not in the bill, correct?
It was not in the bill, but it doesn't
Thank
make it
you.
any less the law.
And was it, not only was it in uncodified language,
It's
where and what
absolutely
court?
in the bill.
And what courts have weighed in on this?
I'm sorry?
Which courts have weighed in on the statute of limitations and the statute of repose that you're talking about?
The U.S. Supreme Court as well as the Maryland Court of Appeals.
And again, for Maryland, they have not weighed in on the retroactivity of the statute of limitations, have they?
I'm not sure I understand your
There are
question.
there are 5 states that have not yet weighed in on the statute of limitations and retroactivity. Maryland is one of them, isn't that correct?
Maryland has certainly weighed in on the definition of a statute of repose and believes that the way that they have defined the statute of repose is correct. And it's not on your bill, I mean, not on your bill from before, but there is a long list of cases regarding the statute of repose in Maryland.
And that language wasn't on my bill either, was it?
Yes, it was.
It was in the uncodified language.
That makes it law. I mean, just because it's in uncodified language, it is still a part of your bill and it becomes law. All you need to do is look at the footnotes in the statutes and it'll tell you. That's what statute of repose
Colleagues,
means.
on the amendment, I would ask the body to please reject this amendment. The whole purpose of this is to expose these predators. The purpose of the bill in 2017 was to give these victims an opportunity to come to court. But more than that, see, California did a 2-year look-back window like we're trying to do. 300 more predators were discovered that but for that look-back window wouldn't have been. That's protecting our children. That's why we're doing this. This isn't revenge. This isn't punishment. And just because certain legislators, because I sure didn't know, and that was my bill, did not know that somehow we might be protecting these entities, that somebody got snuck in on, I'm sorry, what they call it, uncodified language. I'll take responsibility. I guess I'm not that smart, because that was never my intention. That was my bill. This is my bill. When we argued this on the floor, nobody here heard anything about statute of repose. You know when I learned about statute of repose? Yesterday. I did not know that was in my bill. We have a habit in Maryland. We are protecting these institutions for generations and years. You've seen the movies, you've seen the documentaries, you've read the paper. This is an emergency. Possibly, as the U.S. CNN stated, one of the greatest crimes ever committed in this country. And it is up to us to do something about it. Please don't reward sneaky behavior, putting something in that was not intended, because Lord knows I never intended that. It is an opportunity for us to not only reach out to the victims, but also to these predators and let them know, you know what? Maryland cares, because you will find out that we have become a dumping ground for pedophile priests. Other states watch us because this is where they send their bad actors, because we become complicit. 30 years. We can do better. We always talk about what we're going to do for the victims. This is an opportunity not to get caught in loopholes. You should not have a vested right in doing wrong. There should be something better in each one of us. For them to tell me that something in my bill protects these monsters that I've been fighting since I was a little boy is patently offensive. And to know that other people knew about this language, I sure didn't. I guarantee nobody that voted for that bill on this floor did. When you sneak it in, there's a trust that we have, isn't there? When we vote on a bill, it was never argued about a statute of repose. It was never argued in committee. It was never argued on the floor. At no time did anybody here know about a statute of repose. It was snuck in. And now we have somebody fighting from the grave, trying to change a new committee's mind and way. That should not be rewarded. This surreptitious behavior should not be allowed. This was fraudulent. Nobody in their right mind would try and protect these individuals because they snuck some language in the back end after we all thought we had done something good. So you can imagine my heart and how heavy my heart lies to know that my inaction, my name is on a bill now that apparently precluded. Well, for the record and for the courts, that was not my intent. It was never my intent, and that's why I'm putting this bill in. I'm glad that she knew about this, that the majority leader knew about this language, because no one else did. Please resist this amendment.
Mr. Speaker, I think it's a long tradition that we do not question the motives of others in this body, no matter how strongly we feel about something. We all have the opportunity to read bills and understand them. There's a committee process. Obviously, people don't go sneaking amendments in and out of things around here. I'm sure that would never happen to anybody but at the minority party. Just kidding. To lighten the mood. But I think we need to stay away from questioning people's motives. Thank you.
Good point. The
Mr. Speaker.
gentleman from Baltimore City.
Thank you very much, Mr. Speaker. Just a quick note on the statute of repose. And the reason why I feel compelled to really make this comment, having practiced law for close to 30 years, I probably don't think there's anyone else who's dealt with the issue of the statute of repose any longer than myself in this chamber. The statute of repose is really born out of the construction industry, not these type of cases that we're dealing with under this particular area of law. There are special carve-outs with the architects, contractual contracts, and with the construction industry. The genesis really is that after a product has been made or a product has been put out on the market, such as a housing or a construction has been completed, that after a certain number of years, individuals should have the ability to not be liable after 20 years if there is something that happens on that property. I don't see the connection with the statute of repose as it relates to the amendment. And so for those reasons, I would ask the body to resist the amendment and stick with the committee report. Thank you.
Mr. Speaker.
The gentleman from Western Maryland.
Sorry.
Thank you, Mr. Speaker. I don't know much about what my good friend from Charles County was discussing as to the history of this bill and the prior bill, and I appreciate my minority leader and his remarks. I'm not impugning anyone's motives or have any idea of what happened. Like some of us who have spoken here today, I live in two worlds. I'm a legislator here for 90 days, and the rest of the year I'm a litigator. Legislating and litigating have some similarities, but they're not the same thing. And so my perspective on this is very simple and very plain. I don't know how the Maryland Court of Appeals will ultimately rule and how they'll interpret some uncodified language from several years ago and how it affects or protects, whether it be the Catholic Church, whether it be a daycare center, whether it be a monster by any other name that committed an act of child sexual abuse. I don't know how they'll rule on that. Most of you today probably didn't think you were coming in for a law school class, but we've kind of turned it into that in its own way. We're not litigating here. We're legislating. I think in a good faith manner, in a very clear, honest, and direct way, we've tried to establish our legislative intent that we want to open up our courts for an examination, for an attempt to bring justice to children who are sexually abused. We should speak with that widely and clearly in a bipartisan fashion with one voice. We want to give those victims every opportunity possible to present their claims. If the people who serve on the Maryland Court of Appeals determine that that's impossible, leave that up to them. Let's do our job here today. Thank you.
On the amendment, all in favor of the amendment, say aye. Opposed, say nay. Roll call. Supported.
There we go.
Clerk, call the roll.
Mr. Speaker.
Has everyone recorded their vote? Explain their vote.
To explain my vote. given that there is a suggestion, it was not. This was a difficult bill in 2017. It's a difficult bill now, but let me explain my vote. The reason this is so important to me is because I am concerned about setting our civil justice system on its head. There is a reason in civil cases we have a statute of limitations, and there's a reason that we didn't make it retroactive in 2017. When you open this up, it is not just the perpetrator. It is, and it's not the Catholic Church. I'm not defending the Catholic Church. I could never defend what the Catholic Church has been doing for centuries. However, it's your schools, it's all government entities, and this opens it up appropriately, gets rid of the statute of limitations entirely. So there is no statute of limitations. But when I'm 60 and I'm suing an institution for something that occurred when I was 8, do you think that institution can defend themselves when the burden of proof in a civil case is preponderance of the evidence? The answer is no. And this sets our civil justice system on its head. Certainly, I can see where it's gone, but that's the reason I felt it's so important to make this amendment and to speak.
On the amendment. There's no further discussion on the amendment. Clerk, call the roll. Having 5 in the affirmative, 129 in the negative, the amendment fails. Are there any other amendments to the bill or to its title? Hearing none, the bill is ordered, printed for third reading. Clerk, read the next bill.